And therefore, you have just been about 7 years as a lawyer, as a registered legal practitioner.
Yes, correct.
Doesn't that really explain the inadequacy of your knowledge of law, which the judge is talking about in this comment in your work?
Thank you, Chief Justice. Where I did not cite legal authorities, it's not that I was not aware. I was aware of them. There are several other judgments where I am citing them, but I was of the mistaken view, since I've seen the comments, that if they are not in contest, if they are not being contested, then I might not need to cite them in my judgment.
The period of your exposure for the practice of the law has been short and is now being reflected in the comments by the judges who have reviewed your work.
Thank you, Chief Justice. It might be the position, but I've been a judge, I've been a regional magistrate from 2012. And I've been discharging my duties very well with the...
You are not missing, you are missing, there may be a very good person who's a gentleman, who's a lady, and is doing very well as a judge, as a magistrate, but that doesn't necessarily mean that that person is a good lawyer. So we can only measure the capacity of a lawyer by the number of years that person has practiced law after registration. So studying law is not just just doing things that other people can also do who have no law degrees. So we want to know whether you have the competence of a legal practitioner who is wanted as a judge. A judge's basis is an extensive knowledge of law. That's a foundation we can't run away from. A depth of law is a critical requirement. So you have only been in this exposure for 7 years, which is the minimum requirement. Others have been for 20 years. You understand now. What do you say about that?
Thank you, Chief Justice. I understand you. As I said, that might explain the inadequacies noted by the judge, but I intend to improve, as I'm always trying to do, to improve on my knowledge of the law. But the inadequacies, I can't run away from it. I think it has been noted. Thank you.
There has been also this issue of registration. You are saying, I don't think you have not clarified that. What did you mean your work involved at regional level, regional court level, registering of labor judgments? What did you mean?
Thank you, Chief Justice. I was saying that when I became a regional magistrate, I did not register any labor court judgments, but I did that before becoming a regional magistrate. So when I put it down, I think it was a typographical error. What I wanted to say was that I did that 10 years back.
Do regional magistrates do that kind of, discharge that kind of function at the regional court level, registering, well, what they call them awards or not? Is that a function of a regional magistrate?
Thank you, Chief Justice. It's not a function of regional magistrates. They do not register the awards.
Why include it as part of a demonstration of your competence as a judicial officer at your level now? Why include it when you know it's nothing to do with your function?
Thank you, Chief Justice. As I said, I think I misread or misunderstood the question. I thought the question was asking whether I had any interaction with the labor court in my career life.
You realize that if we had not been able to pick up some of this kind of mistake, we would have been misled to believe you as a matter of fact, isn't it?
I admit, Chief Justice, and I am sorry for that.
I think it goes back to integrity of a judge. A judge must always align himself or herself to truth, isn't it?
It's correct, Chief Justice.
What kind of a judge are we talking about who's misrepresenting facts about himself and what he does?
Thank you, Chief Justice. The misrepresentation did not happen intentionally. It was an oversight. Maybe I did not edit the document correctly, and it came out.
We have a very careless judge, isn't it?
I admit.
So what kind of a judge is that?
Thank you. I would say that
Say what?
It's a judge who needs to work much on his on his way of looking at documents, to make sure that he is meticulous with his work. He has a lot to do. He has a lot of work to do to correct the deficiencies.
Then you have been facing referrals from the regional magistrate court to the constitutional court, isn't it?
Yes, Chief Justice, I did, I think 2 of those.
In your performance of that function of referring, which is almost the exercise of the regional court work, where you refer matters to the Constitutional Court, you have understood, as I indicated earlier, that for it to be referred, the constitutional question must be vexatious or frivolous.
Thank you. If it's vexatious or frivolous, it will not be referred.
Just answer, have you understood your duty as being that you refer a matter, a constitutional matter, to the Constitutional Court as a regional magistrate if that constitutional question is vexatious, is frivolous or vexatious? Is that how you have understood your duty?
Thank you, Judge. Thank you, Chief Justice. I think you had not, maybe I did not explain myself correctly. I was saying the judge should refer the matter unless it is frivolous or vexatious, which means that if it is frivolous or vexatious, it cannot be referred.
Let me take you on your own word. Is that how you understand your function? Is that how you understand what you should do in terms of that law?
Thank you.
Is that how you understand your duty as being in terms of that law?
Thank you. My understanding of my duty is that if a question if a question is arise during the proceedings, and a party has requested the court to refer it, I then consider whether the application is frivolous or vexatious. And if I find that it's not frivolous or vexatious.
Is that how you understand the law yourself? You are telling me what you understand. Is that how you understand it as a regional magistrate?
Correct.
Which you should understand it if you become a judge of the labor court. Is that what you are telling us?
Correct you, Chief Justice. That's how I understand it.
If I tell you now that that is a wrong understanding of the law, what do you say?
Thank you, Chief Justice. I am prepared to learn.
That is a wrong understanding of the law. It is the request, not the constitutional question, that should be frivolous or vexatious. It's the request by a party to send the constitutional question to the Constitutional Court, which must be considered by a regional magistrate whether it is vexatious or frivolous. So you can see you have been totally lost all the way, all the time.
Thank you, Commissioner. Maybe it's this environment, but I wanted to say the request. That's why I said the constitutional issues will be referred to the Constitutional Court.
You're getting wise after I've enlightened you. Thank you. Okay. Yes, we have come to the end of your interview. You are excused.
Thank you, Chief Justice.
confirm we have Mupindu Sandra.
Yes, Honorable Chief
All
Justice.
right, thank you. As indicated this morning, I'll ask you 3 questions. And the first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act? And how does that classification determine whether arbitration is voluntary or compulsory?
May you kindly repeat your question, Honorable Chief Justice?
What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act? And how does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Honorable Chief Justice. In answering your question, Section 93, subsection 5, provides for conciliation. When a conciliator would have resolved, when a conciliator would have attempted to conciliate a dispute and would have issued a certificate of no settlement, if it is a dispute of interest and parties are involved in essential service, then the conciliator will refer the dispute to compulsory arbitration if the parties are engaged in essential service. And secondly, the conciliator, with the agreement of the parties, may also refer a dispute to voluntary arbitration. And then lastly, the conciliator may also refer a dispute of right to compulsory arbitration. A dispute of right is a dispute which is a dispute other than a dispute of interest. And a dispute of right is defined in the Labor Act, is a dispute which involves legal rights and obligations. And this may be occasioned by an actual or alleged unfair labor practice, a breach or alleged breach of the Labor Act or any regulations made under the Act, or a breach or alleged breach of a collective bargaining agreement or a contract of employment. So the distinction is important because these disputes, the classification of dispute as to dispute of interest and dispute of right is because these two disputes, they differ in their nature as well as the method of dispute resolution. So why a dispute of interest is referred to compulsory arbitration is because there is also a need to retain essential services. So now, does the classification determine whether arbitration is voluntary or compulsory? I think I have already answered that. If it is a dispute of interest and parties are involved in essential services, then the conciliator will refer them to compulsory arbitration. And then when the dispute is, the conciliator can also refer a dispute, whether dispute of interest or a dispute of right, to arbitration upon the agreement of the parties. And then lastly, if it is a dispute of right, the conciliator may still refer again the dispute to compulsory arbitration. That is my answer.
The second question is as follows. What steps must a labor court judge address and decide a constitutional question arising during its proceedings, if any?
Thank you, Honorable Chief Justice. Section 175, subsection 4 of the Constitution of Zimbabwe provides that if a constitutional matter arises in any proceedings before the court, the person presiding over the court may, or if so requested by parties to the proceedings, shall refer the constitutional matter to the Constitutional Court if the presiding officer is of the view that the request is not frivolous or vexatious. So the steps that must be taken by the labor court to properly address and decide a constitutional question arising from the proceedings are as follows. Firstly, it is important for me to state that there are two scenarios wherein a referral may be made by a constitutional judge to the constitutional court of a constitutional matter. That is, if the labor court judge, Mero Muto, intends to refer a constitutional matter. If that is the case, then the constitutional judge has to invite the parties to the proceedings to make submissions on the constitutional issues or constitutional question for referral to be determined by the labor court, and also to state the specific constitutional matter, the constitutional question which is to be decided by the constitutional court. And then the second scenario is whereby the request is made by either party to the proceedings. In those circumstances, the labor court judge has to first of all make a determination whether the request is frivolous or vexatious. A constitutional issue will not arise from a vacuum. It has to make a determination from the facts which will be before the court. So if there are any factual issues, the labor court judge has to make findings of fact That is a requirement to make findings of fact first, unless if there are no disputes or there are no factual issues, and then the parties have to file an agreed statement of facts. And then the Labour Court judge has to attach, form number Form LC10 is to be used when a referral is made to the Constitutional Court. And the Labour Court judge has to ensure that Form LC, the record of proceedings is attached to Form LC10. And this record of proceedings will include, if they are factual, if there were any findings of fact that were made by the court, they have to be part of that record. The constitutional question that would have been written or stated by the court for determination. And then the record of proceedings must also include submissions that would have been made by the parties or arguments made by the parties on or regarding what their arguments they will make before the Constitutional Court. And then if a referral is made where a party has requested a referral, there must be a draft order as part of the record that is being referred. And then a registrar, the Labour Court judges to instruct or direct the registrar of the Labour Court to prepare and transmit the record to the Constitutional Court. And then that is to be done within 14 days. The registrar has to prepare and transmit the record, but before transmitting the record, he has to be satisfied and ensure that the record is correct and that the record is a true reflection of everything that is part of the record, that the record is accurate, and then a referral is supposed to be done. So what is very important in this procedure...
Just assure me you're not reading from anything there?
No, I'm not reading from anything. I just wrote the question.
Can you just check? I suspect somebody has given the answer. She's not reading. All right, proceed.
Thank you, Honorable Chief Justice. I think I was saying the important step that...
You give the impression you have crammed somewhere.
No.
No.
Yes,
all right.
Honorable Chief Justice. What is important is there is an important step which is supposed to be taken by the Labour Court judge, that is making findings of fact that is not supposed to be done by the Constitutional Court. The duty of the Constitutional Court is to determine the constitutional issues. So any factual issues have to be determined by the Constitutional Court. And also the Labour Court judge should not just refer any constitutional issue, but one which is an effect of resolving the dispute that will be before the Honorable, but that will be before the court, the Labour Court. That is my answer. Thank you, Honorable Chief Justice.
The third and last question is as follows. What is the appropriate test for determining whether the Labour Court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labour appeals?
I will also kindly request you, Honorable Chief Justice, to repeat the question.
What is the appropriate test for determining whether the Labor Court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals. To warrant appellate court interference in labor appeals.
Thank you, Honorable Chief Justice. In answering your question, an appeal from the Labor Court to the Appellate Courts, which is the Supreme Court, is provided for by the Labor Court, is what is provided for by the Labor Act, is only a question of law. Meaning, when the Appellate Court, which is the Supreme Court, has to interfere with factual matters, it is because there will be gross irrationality in the facts, because the Labor Court is the final court of appeal on factual matters. And the Appellate Court, which is the Supreme Court, will only interfere with a Labor Court's factual matters where there is gross misdirection by the Labor Court judge in determining the issues, where a Labor Court judge would have made a finding of fact which is not even supported by the evidence that will be on record, or would have made a finding, or would have failed to make a finding of fact leading to a misdirection in the law. In those circumstances, the Appellate Court would definitely interfere with the Labor Court's factual findings, because they will be grossly irrational. That is my answer. Thank you.
Yes, thank you. I will now hand you over to the other commissioners for further questions if they have any. Yes, DCJ.
Thank you, Honorable CJ. Good afternoon, Ms. Mpindu. I have one question for you. What distinguishes a so that's not the one I want to ask. Don't have into my questions. Can I just bring it back? That's yours. I don't know what I've been doing. Yes, sorry about that. Yes, given the scope of the matters that appear before the Labour Court, can you list the possible agents that may represent parties before the court as highlighted by the Labour Act, Chapter 2801? Found it.
Thank you very much, Honorable Deputy Chief Justice, for your question. In terms of the Labour Act, the possible agents which may represent parties before the Labour Court are as follows. A party can be represented by a legal practitioner who will be registered in terms of the Legal Practitioners Act, and that legal practitioner must have a valid practicing certificate. Secondly, a party can be represented by an official or a member from a registered trade union or employers from a registered employers organization to which that party will be a member. In respect of companies, a company director, a company secretary, a company legal advisor, or a member from the human resources can also represent the party in the Labour Court proceedings. Thank you, Honorable DCJ. That's my answer.
Yes, thank you for your answer.
Thank you, Chief Justice. If I may proceed to put questions. Mrs. Mpindu, there are certain concerns around your rate of clearance of cases that are brought before you, and these concerns are coming from the monitoring and evaluating team. Are you aware of that? Are you aware?
I'm not yet aware of that, Honorable Commissioner.
Maybe let me bring it to your attention. There's been a very grave concern pertaining to your rate of clearance, whereas other magistrates in similar position as yourself have been doing more than 50 cases, for this quarter. You only did 3 trials per month, and you may want to tell the Commission as to why you have not been up to standard in your clearance of cases.
In responding to your question, Commissioner, I'm not quite sure whether the 3 trials are for the month of January, February, March, and April, but I think I may answer in respect of the month of April. If I completed 3 trials in that month, is because the prosecutor who is prosecuting in my court was on vacation leave, or study leave for 2 weeks. And I did not have a permanent prosecutor in my court. And that is the reason why I was not able to complete more cases in the month of April. And then in the month of March, I was also assigned to Relief Bindura Regional Court, wherein in that month, I was sitting at Harare Regional Court as well as Bindura Regional Court. That also affected my rate of clearance of cases at Harare Regional Court, because during those times that I would go and preside over cases in Bindura, I would not be able to finalize the cases that I had already started at
go to Bindura?
in March.
Okay, maybe let me put it broadly.
Okay.
Yes, in 2024, you only completed 50 trials. And in 2025, up to now, you have only done 16 trials. So this translates to an average of 3 trials per month, if the calculations were to be done. And this is below expectation, Mrs. Mpindu. That's why I'm asking, do you have any challenges in ensuring that you deliver your judgments promptly?
Thank you so much, Honorable Commissioner. I do not have any challenges in pronouncing my judgments promptly, as I do not consider myself a lazy judicial officer because I'm a career judicial officer, and I also know the guiding principles in terms of the Constitution that I'm supposed to execute my duties as a judicial officer with reasonable promptness and also to deliver them speedily. I do not take long as far as pronouncement of judgments are concerned. I think if I was doing that, my immediate bosses would have brought that to my attention, that I'm not delivering or pronouncing judgments timeously. As far as I'm concerned, I pronounce my judgments timeously. Then if it is the issue of rates, completion of trial rates that you are making reference to regarding the year 2024. Regarding the year 2024, I presided over many robbery cases until I had to bring it to the attention during our internal meetings that is court number 16 where I was sitting, the only court which should preside over robbery matters. And it was not only once, but even the prosecutors, they had to confirm that they would refer robbery cases to court number 16.
At least I've brought to your attention something that is coming from the monitoring and evaluation team. Anyway, coming to the pre-interview test, I noticed that you did not do so well, and your marks were very low, and worryingly, because you scored no marks, or maybe 0 out of 30. How then would you be a competent judge of the labor court when you are not so conversant with what the lab assistant I put?
Thank you so much, Honorable Commissioner. In answering your question, yes, I might have not performed very well in the examination that was written. And it being an examination, when a labor court judge is sitting and presiding over cases, it will not be an examination. Why I say so is because as a labor court judge, you know the case that you'll be presiding over well before you preside over the case. Pleadings would have been filed. You go through the said pleadings. You are able to even identify the issues before you even preside over the cases and prepare for the said case. And then if it is a trial, you are conducting a hearing, you hear all the evidence. It's not in an examination environment. You are not at the tail end.
Thank you, Chief Justice. I'm answered.
Yeah, thank you. Thank you. Thank you. Yes.
Sorry.
It's okay, that's fine. Thank you, Chief Justice. I have no question.
Thank you, Honorable Chief Justice. And question for you, coming in two parts. And the first part reads, how should the phrase redress any dispute in section 63(3)(a) of the Labour Act be construed? And the second part, does that phrase of a determination or only to initiate conciliation? The second part, does the phrase redress any dispute permit a designated agent to entertain appeals on the merits of a determination or only to initiate conciliation?
Thank you, Honorable Commissioner. In answering first question, the phrase redress in section 63 subsection A of the Labour Act is to be construed to mean to remedy a dispute or an unfair labor practice, that is to hear and determine the said dispute or unfair labor practice. In the case that I read of Isoko and Case versus Darikwa, that term, not phrase, I may put it, redress, was construed to mean to remedy or to put right in unfair or called upon to make a determination or to adjudicate in unfair labor practice or a dispute referred to him or to her, giving a final decision in that regard. Then your second question, whether the term redress also permits the designated agent or does not give the designated agent appellate authority or appellate jurisdiction, because it's not stated as such. The designated agent in terms of section 63(3)(a) is given powers to remedy, so is given powers to redress a dispute or to attempt to redress. If it's an attempt to redress, that's where conciliation comes in. Because if the designated agent is to attempt to redress the dispute, that is conciliation. And to remedy a dispute is not conciliation, is to hear and determine a dispute and make a determination, disposing of the matter and also pronouncing is what becomes of the rights of the parties, which decision will be final. That is my answer.
Thank you, Honorable CJ.
Yeah, thank you.
Good afternoon, Mrs. Mpindu.
Good afternoon, Honorable Judge President.
To enforce the right to equal remuneration for similar work provided for under section 65.
May you kindly repeat your question, Honorable Judge President?
Yes. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under section 65 of the Constitution of Zimbabwe.
Indeed, the Constitution of Zimbabwe, in terms of Section 65, provides for equal remuneration for similar work provided. This right is also provided for in the Labour Act when it comes to remuneration for similar work. I'm not quite sure of the exact provision, but the said provision was introduced by the amendment which was made in 2023 that employees, whether male or female, are supposed to be paid equal remuneration for similar work. So if that does not happen, in my view, that is a dispute of right which one can sue, because this is a right which would be enshrined. So if that right would be violated, probably one may want to approach the formal cause for resolution, because that would be a violation of your answer.
I thank you. Thank you, Honorable CJ.
Ms. Mpendo.
Good afternoon, Commissioner.
Can you walk us through what a collective bargaining agreement is in terms of the Labour Act? Requisites of a valid collective bargaining agreement.
Thank you so much, Commissioner. In responding to your question, the term, the phrase collective bargaining agreement is defined in Section 2, which is the interpretation section, as to any agreement which is negotiated between the parties, the body representing the employees and the body or trade unions or workers' committee and the employers. The employer's representative body, with the aim of achieving, with the aim of improving working conditions for employees in the workplace. That is my answer to your first question. Then on the prerequisites, collective bargaining agreement is provided for in section number 65. Subsection 5 of the Constitution of Zimbabwe, meaning it is entrenched as a right that the employers' organizations, the employees, trade unions, they have a right to collective bargaining, save for members of the security forces. And this right is also has been made or has been also provided for in section number 74 of the Labour Act, as well as section number, I think should be section number 24 of the Labour Act, which also allows Workers' Committee to also collectively bargain at the enterprise level. So regarding the prerequisites for collective bargaining, I'm of the view that there is need for a legal framework to ensure that the parties, that is the body representing the employees and the body representing the employers, have to collectively bargain. There must be a legal framework. If we are to go by the provisions of Section 2A, I believe, it also provides that the purpose of the Labour Act is to ensure that the parties, that is the employers, the employer, the employer and the employees, they also collectively bargain, meaning already we have a framework providing for collective bargaining. So the first prerequisite is for a legal framework providing for collective bargaining, which is already there in the provisions that I've made reference to, which is section 74, section 24, and also section 2A of the Constitution, of the Labour Act. And the second prerequisite, collective bargaining, since it involves negotiations between the body representing the employer's organization and the employees' organization, these have to be registered for them to be able to collectively bargain. So there is need for the employer's body and also the employees' body, which are trade unions or workers' committees, a prerequisite. And also the other prerequisite is the parties must be prepared to enter into negotiation in good faith, so that at the end of the day, they arrive at mutually agreed and acceptable collective bargaining agreements. That is my answer. Thank you.
Is it your understanding that unregistered trade unions and employer organizations barred from engaging in negotiating and emerging with valid collective bargaining agreements?
May you come again, Commissioner?
I got the impression that in your response you indicated that the trade unions and the worker organizations have to be registered in order for their collective bargaining agreements to be valid. And my question would be, is your understanding then that the inference can be drawn that if you are not registered, you cannot have a collective bargaining agreement?
Okay, thank you so much, Commissioner, for bringing that to my attention. Section 74 of the Labour Act is very clear that even unregistered trade unions and employers' organization, they can also collectively bargain.
So it is not the case then that registration is a prerequisite for a valid collective bargaining agreement?
Yes, because there's a proviso.
So it is not a valid prerequisite for a valid collective bargaining agreement to be.
Yes, because there are some employers' organizations which can also bargain with trade unions which are not registered. Yes.
Okay, I'll grant you that, yes, there has to be beyond negotiation. What else is required? Parties to the negotiations. We have agreed that is subsist.
I think I made reference to the issue of negotiating,
Yep.
or negotiating in good faith.
Absolutely, yeah.
Yeah.
So there has to be negotiation. Negotiation is one of the pillars.
Yes.
Beyond that pillar, are there any other pillars? That's my question.
I'm not aware of the
All right,
other
okay.
pillars,
No, thanks.
Commissioner.
Thank you very much.
Given my understanding that it's a negotiation.
Okay, thank you very much.
Okay.
Thank you. Honorable Chief Justice, good afternoon, Mrs. Mpindu.
Good afternoon, Commissioner.
I have one question for you. How does Section 90, capital letter A of the Labour Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
Yes, may you kindly repeat both your questions, Honorable Commissioner, so that I ensure I have understood your questions.
How does Section 90, capital letter A of the Labour Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
Okay, thank you, Honorable Commissioner. Section 90, capital letter A of the Labour Act provides for the informality and the flexible character of the Labour Code, wherein the Labour Code it provides that the Labour Code is not bound by the strict rules of evidence, and that the Labour Code judge may even ascertain any relevant facts using any means. And by doing so, the Labour Court judge has to ensure that, or using any means which the Labour Court judge thinks is fit in the circumstances, but at the same time, the Labour Court judge has to make sure that that laxity or that informal process or flexibility is not unfair or unjust to the parties, that should not cause prejudice to the parties. So the Labour Court judgments and the Supreme Court judgments, they also reaffirm this informality and flexible character of the Labour Court, is provided for in Section 90, capital letter A, meaning even the Labour Court judge can adopt the inquisitorial role and descend into the arena, even calling witnesses and asking them questions, because it's not bound by the strict rules of evidence.
Thank you. Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Good afternoon, Mrs. Mpindu.
Good afternoon, Commissioner.
I have two questions. The first one is, what would you regard as your most significant contribution to the law and to the pursuit of justice in Zimbabwe?
Yes, may you kindly repeat your question?
What
Honorable
would you
Commissioner.
regard as your most significant contribution to the law and to the pursuit of justice in Zimbabwe?
I didn't get the last part.
To the law and the pursuit of justice in Zimbabwe.
In Zimbabwe. Thank you so much, Honorable Commissioner. In responding to your question, my answer is I am a career judicial officer for almost 2 decades, wherein I've been presiding over cases. If you are to look at my CV, I've presided over civil cases. I've also presided over criminal cases, wherein I've been able to pronounce judgments in those cases, wherein I would be applying the law to the facts in those cases and resolving disputes in regard to those cases, and also to expeditiously resolve those the disputes in those matters by ending judgments with reasonable promptness. What I also consider as a most significant contribution to pursuit of justice, if you are to go by my questionnaire, I underwent training as a child witness, or I underwent training regarding child witnesses in 2021, wherein I acquired knowledge as to how to deal with child witnesses in our courts, given that the regional courts deal mostly with cases involving sexual violence, wherein children are survivors in those cases. And in most cases, children, while...
Hold on. You've been trained for it.
Yes.
How have you contributed to the pursuit of justice using that
Using
training?
that.
It's about what you've contributed rather
Okay.
than what you've done for yourself.
Thank you. What I have done after acquiring that knowledge was also to train my fellow colleagues. My fellow colleagues, I am referring to fellow regional magistrates who also preside over similar cases, and also other magistrates, provincial magistrates, senior magistrates and magistrates, because they also preside over cases which also involve children in their courts, whether sexual offenses or any other offenses. That is my contribution.
Okay, second question, and this is a follow-up to the questions the Attorney General was asking you. You scored 0 on substantive labor law and 6 out of 30 on procedural labor law. In an examination where other people similar to you were scoring marks as high as 20 or 22 out of 30, same examination conditions you're complaining about. You are saying when you go to the labor court, or if you go to the labor court, you would not be operating under examination conditions and you would have time to research. But you would not have the luxury of time. You must at least have an understanding of the fundamentals of the laws and the procedure, even just to preside over a matter and hear it. How would you hope to cure this massive deficiency if you are appointed to the labor court?
Thank you so much, Honorable Commissioner, for your question. In answering your question, I was not born a judicial officer, but I am somebody who is willing and keen to learn, even write judgments. I had knowledge regarding writing judgments in civil and criminal matters. I don't think I'll find it difficult to also read labor jurisprudence, to read labor law judgments. A good judicial officer is somebody who knows where to find his or where to find the law applicable to facts which will be before the judicial officer.
You think you should
Why
be given an equal chance as someone who already knows enough of the law to score 22 out of 30 against your 0? You think you should get an equal chance with a person like that?
Why I scored those low marks, that's why I want to explain, is because I think I had to write that test in less than an hour. I lost my documents on the computer when I was almost 3/4, and then I had to restart. So I did not have enough time. In as much as I had already grasped the concepts in it, but I forgot to save my document. And then I was also now racing against time. It's not that I had failed totally to appreciate the aspects, because I had even read some of the cases which I thought were applicable in the examination test that I underwent. Thank you.
Thank you, Chief Justice. I have no further questions.
Thank you, Chief Justice. Good afternoon, Mrs. Mpindu.
Good afternoon, Commissioner.
Great. Earlier on, during this interview, an issue was raised regarding your court performance, which is below expectation. And I'm noting that during the performance appraisals of last year, this issue was raised to you again, right? Earlier on, the issue was discussed. We were saying it was raised during the monitoring and evaluation exercise that is currently going on at Ararama State Court. But this issue was raised to you earlier, again last year, where I read, she has to improve on the completion of trials within 1 month or sexual offenses in 3 days. I take that comment is arising from your statistics for last year, where the statistics reveal that you completed 50 trials, and the monitoring and evaluation exercise is also revealing that to date you have completed only 16 trials. You proffered an explanation for that, but my worry is the whole essence of performance evaluation management exercise is that you and your supervisor, you agree on certain challenges that you may have been, that you may have faced during the year under review, and you also try and come up with interventions, what therefore needs to be done for, so that you don't encounter the same challenges. But my worry now is, it seems instead of us seeing an improvement, right, this year, the situation remains the same, if not getting worse. You may comment on that.
Thank you very much, Commissioner. I would say the situation is not getting worse. If the statistics were presented to me are correct, that this first quarter, I have already completed 16 cases. It means there is an improvement, because we are still in the first quarter, and I had already mentioned the predicaments that I had in trying to complete more cases. It's so unfortunate that reference is made to the year 2024 and this first quarter. Unfortunately, no reference is made even to the previous performance. I went to Chitungwiza in 2011, which had a backlog of more than 200 cases. I reduced that backlog at Chitungwiza Regional Court, and I also worked at Bindura Regional Court from 2016 to 2020. There was also, it was clogged with a backlog of about 300 cases. By the time I was transferred from Bindura Regional Court, there were less than 50 cases, if my memory serves me well. As I'm saying, it's just unfortunate that the statistics that are being used now is for the year 2024, which I've already given an explanation that during that period, that is the time when I was doing more cases more robbery cases involving multiple accused persons, multiple counts in those cases. And regarding this first quarter of the year, I've already explained my predicament that there was another time when I did not have a prosecutor for almost 2 weeks. And 2 weeks is quite a long time.
Thank you for that explanation. I take it. But I think you understand why these statistics have now become of interest and of concern this year is because you now want to move on to a higher office with more responsibilities, and I would expect that you will be telling me that these are my have been doing very well previously, Tungiza, wherever you're mentioning, and I'm still, my statistic keeps on going up and keeps on improving. But the situation we have is that whilst you may have been doing very well, we're doing fine, right? But now your statistics are going down, which is a cause of concern. Would expect them actually to be going up as you grow in the even as you grow in the profession, and as you now start to seek for bigger challenges. Being a judge of the labor court, it comes with it a lot of challenges. It comes with it a lot of responsibilities. It comes with it a lot of growth, and that is the growth that I'm looking for. That's the growth that I'm asking for. That's the growth that I'm not seeing as far as your current work is concerned. Thank you, Chief Justice. I have no further.
You want to answer? You seem to want to answer that. You may do so.
I thought probably the Honorable Commissioner wanted me to explain, unless if she was satisfied with my answers that I had given, that I'm somebody who is willing to improve. And also, as I had already stated, Commissioner, before you, that I don't consider myself to be somebody who is lazy, but I consider myself as hardworking, as diligent, as competent, and maybe the other setbacks are that you will not be working alone in a court setup. There are other also stakeholders, maybe who will not be doing the same things that you'll be doing. Sometimes cases, they don't move, not because I am not using the court and case management skills that I have, but there are times when there are situations beyond my control which will also impede on my output regarding my work. Thank you, Honorable Commissioner.
Thank you. You may switch off your mic. So, you want us to believe that the data that is before the commissioners is really conspiring against your competence as you claim it.
Kindly repeat your question, Honorable Chief Justice.
According to what you have been saying about these critical issues, you seem to want us to believe that the data that is before the commissioners is conspiring against your claimed competence as a judicial officer.
Thank you, Honorable Chief Justice, for your question. In answering your question, I would say, yes, the data is before the statistics, the data is before you, but I still believe I am competent as regards as executing my duties is concerned.
And logically, let's reason logically. So the data is really conspiring against your claimed competence. In other words, the data is telling lies about you and your competence as you see yourself.
The statistics are correct because those are the statistics which are there. But I think I have given an explanation regarding those statistics. Not that they are saying a lie, no. But the statistics are there, but I'm offering an explanation as to why we have such statistics.
You know that data doesn't lie,
Yes, Honorable Chief Justice.
right? And that we need to proceed on that principle that data does not lie.
Yes, Honorable Chief Justice.
Now, if we do, which you agree we should do, we should accept that you failed very badly in the interview that you wrote in the written test.
In answering your question, Honorable Chief Justice, indeed I failed. That is data which is before you. But the reason why I'm appearing before the commissioners is because I'm being afforded the opportunity, or I'm being asked as to why I performed badly, and that is why I'm giving an explanation regarding that performance.
The data does not, at the moment, based on that data, you are a low-grade performer. In other words, you performed amongst the poorest performers. You got 0 on the labor law. You generally were in 39%. Others were in the 79%. We had some yesterday who were 79%. So you are far, far way below. That's what data tells us, isn't it? You agree that is a sign of a low performer. You are at a lower grade of performance in that examination.
Thank you, Honorable Chief Justice. Regarding that examination,
Officer, it also shows you are a lower performer. You are in the low grade performer, isn't it?
as far as the data, thank you, Honorable Chief Justice. As far as the data that has been presented before you, that is what it shows. But I've already provided an explanation before the Commission.
Why are we saying that in in 2025, where you are having 16 trials completed, one magistrate is already at 50 trials. Surely that is a sign of a low-grade performer. One magistrate, same circumstances as regional magistrate, is up there clearing 50 cases from January to now. You clear only 16. You accept that you are in the lower grade performance in this respect.
Thank you, Honorable Chief Justice. Given your statistics that you have highlighted to me of a fellow colleague or a former regional magistrate clearing or completing 50 trials against my 16 completed trials, I'm of the considered view that this figure of 50 trials is in regard to fast-track courts, wherein those courts, they just deal with simpler matters. I'm not in the fast-track court. I'm in the general court, wherein the nature of the cases that I deal with are quite different from the one who is completing 50. Should I be in that fast track court?
Well, let's not take which court is what case. Whatever you say, 50 and 16 don't compare,
Yes, those two figures. they
regardless
don't
of the
compare.
difficulties of cases. It can't.
Yes, Honorable Chief Justice.
You then have the same 2024, where one magistrate, 2024, completed 105 cases. For the whole year of 2024, that magistrate was at 105. That's a regional magistrate. Same jurisdiction yourself, and you are only completing half, for 50 for the whole year. Again, you are in the lower grade performer. Regardless of these other excuses you are giving, you are in the low grade there. Consistently, 2024, the whole year 2025, you are beginning the same kind of approach. Don't you see that?
Thank you, Honorable Chief Justice. I think I have already answered that. I should not argue with you, Honorable Chief Justice. I think I have already explained the figures.
All you need to do is improve yourself. Then you can compete with these people. Because these are the regionals who are not before us.
Indeed, I'm willing to
Do
improve,
you
Honorable
understand the
Chief.
difficulty you are having?
Yes,
These
Honorable.
high performers are not here.
I do appreciate.
Yes. So we need to see regional magistrates perform at that high level for them to go to the judge levels. That's a standard we have set. You understand that?
I understand, Honorable Chief Justice.
Yes. Okay. Yes, thank you. We have come to the end of your interview. You are excused.
Thank you so much, Honorable Chief Justice, Deputy Chief Justice, and the Commissioners for affording me the opportunity to appear before you.
Yes, just confirm. We have Mura. Yes. Question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act, and how necessary?
Thank you, Honorable CJ. What distinguishes the two concepts are as follows. A dispute of right relates to legal obligations that arise from a contract of employment, legal rights, legal duties, specific of interest. According to the definition section of the Labor Act, it says anything else which is not a dispute of right becomes a dispute of interest. Getting to the second part of the question, how this affects the classification as to whether a matter goes for voluntary arbitration or it goes for compulsory arbitration. A dispute of rights is an issue where rather there is a dispute of rights. That issue is referred for compulsory arbitration. And where it is a dispute of interest, it is an issue that goes for voluntary arbitration.
The second question is as follows. What steps arising during its proceedings?
Honorable Chief Justice, my response to the question is as follows. Where a constitutional issue arises during the proceedings before a labor court judge, issue before the matter to the Constitutional Court by reason of the fact that there is a constitutional issue that has arisen during the proceedings. And once he sees with such an application, a labor court judge may, in the exercise of his or her discretion, refer the matter to the Constitutional Court unless he or she finds that the application is frivolous or vexatious. And the second scenario, where a constitutional issue may arise during the course of proceedings before a labor court judge by reason of the fact that the labor court lacks the requisite jurisdiction to entertain or to make a declaration of constitutional invalidity of any sections of the law, the labor court will not deal with such an issue. It may elect, again in its discretion, to proceed and deal with other issues which fall within its ambit and its jurisdiction, but without dealing with the issue of a constitutional nature.
The third question and last question is as follows. What is the appropriate test for determining whether the labor court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals? what is the appropriate test for determining whether the labor court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals?
My response, Honorable Chief Justice, to the question, an appellate court, in making a finding that the proceedings before the labor court is grossly, is a consideration of the facts that would have been placed before the labor court in conjunction with the findings that would have then be made as well by the labor court. The labor court, in making its decision or in making its determination or order, lacked jurisdiction, lacked the requisite jurisdiction to make such an order. The appellate courts will definitely interfere with the finding of the labor court. And secondly, when an appellate court comes to the decision that in arriving at that decision, either the labor court had an interest, acted maliciously, or acted corruptly in arriving at that decision, the appellate court will definitely interfere with the decision of the labor court on the basis that it was grossly irrational.
Yes, thank you. I'll now hand you over to the other commissioners for further questions if they have. Yes, TCJ.
Yes, thank you, Honorable CJ. Good afternoon, Mr. Murambasina.
Good afternoon, Honorable DCJ.
Yes, I have one question for you, and it goes as follows. Given the scope of the matters that appear before the labor court, can you list the possible agents that may represent parties before the court, as highlighted by the Labor Act, Chapter 2801?
Pardon, Honorable DCJ, may that be taken again?
Yes. Given the scope of the matters that appear before the labor court, can you list the possible agents that may represent parties before the court as highlighted by the labor court? Sorry, by the Labor Act.
Thank you, Honorable DCJ. The agents that may appear on behalf of, that may represent parties is provided for by the Labor Court Act. Firstly, a registered legal practitioner, registered in terms of the Legal Practitioners Act. Secondly, a member of the Workers' Committee or a trade union, a registered trade union, or a confederation of trade unions. Such an agent, such a party may also appear before the labor court in a representative capacity. Thirdly, a member of an employers association or federation may also appear in a representative capacity before the labor court. That's my response.
Yes, thank you. Thank you for your answer.
Thank you, Honorable Chief Justice. Good afternoon, Mr. Mrambaswina.
Good afternoon, Honorable AG.
Mr. Mrambaswina, I think it is common cause that previously you encountered certain challenges that then prevented your consideration. Today, I would like to find out from you whether you have taken any measures to. So my question is, what measures have you?
Unfortunately, Honorable AG, I have to admit that I have not taken any steps.
But however, to your knowledge, are there any legal impediments that may inhibit your consideration for appointment to the office of judge of the labor court?
In my respectful submission, there are no impediments that can stand in my way to appointment as a labor court judge.
I also want to confirm something that you have put on your questionnaire with regards to the same issues. Just for you to confirm that you were previously suspended, but you were reinstated and the matter has since been withdrawn and there is nothing pending against you. Would you like to confirm that?
Yes, I will confirm that by reason of the fact that a withdrawal is there.
Did you attach the withdrawal to your papers for consideration by the Commission?
In view of the fact that there was nothing from the regulatory authority, unfortunately, I did not attach a copy of the withdrawal.
Thank you, Honorable Chief Justice. I'm answered. Thank you, Mr. Mrambaswina.
Yes, let's put it, the record straight so that when we discuss this matter, we are all at the same page. The Law Society still says that you stand convicted of misconduct. Whether you agree with it or not is not really for the Commission, and that you are pending sentencing at the moment. There may be other legal remedies for you, we don't know. Is that correct, that you are still under that conviction the Law Society has advised the Commissioner of? That is a case of relating to the complaint to the Law Society by Mr. Mamvura Maruta. You understand that?
I understand that, Honorable CJ, but the name I don't seem to.
The conviction. It says the sentence is yet to be imposed. You were convicted of a misconduct. Yes. And you have not, there have not been any measures to either reverse that conviction or the Law Society admitting that you are no longer under that conviction. We don't have any record. What we know is that you are still under that conviction. Is that correct?
Yes, that is correct, Honorable CJ. And like I indicated earlier on, delays is not to my knowledge.
Yes, that's really for the Law Society, not for this for the records of the commission, you accept that as far as well the commission is concerned, and until that is removed, there's not much we can do. We have to work on it. So you see where the difficulty is. Also, another complaint against you under investigation raised by Ms. Melba Moore Mashindi. You know about that?
The only one which, there were only two which were brought to my attention.
Yeah.
I wouldn't know whether that is the second one.
Yes, I don't know whether it's second or first, but it's Mashindi. And they say the matter is still under investigation.
Yes.
And you remember the allegation of, I think that there was some name put by you or your firm, which you deny completely that is nothing to do with a firm, in some documents. You remember?
Yes, I remember
Yeah,
that.
That's the one. And you are saying there's a difference between the name of the firm. You are not Mramba Tswina. You are Mramba Swina. That's a difference you are saying. You remember that case?
Yes,
All right.
Honorable CJ, I remember that.
You remember that?
Yes.
You agree it's still under investigation by the Law Society?
Whilst the matter is under investigation, I gave my response in detail, a copy of which I attached
Yeah.
when called upon to do so by the Commission.
Yes, so, but the matter has not been concluded by the Law Society's tribunal, not yet.
Not yet concluded.
All right. Yes, fine. Yes, thank you. You can continue.
Thank you, Chief Justice.
Yes, thank you. Yes,
To clarify this, that you are saying that you are not the one moving this case. You are not the one who is seized with the prosecution of this case. I think it is in your interest also that you clear. With my experience with the Law Society, it is not very difficult with my life. Then they simply deal with it. That's how I know it to work, right?
Thank you for the advice.
Thank you.
Thank you, Honorable Chief Justice. I have no questions.
Honorable CJ, I do not have any questions for Mr. Mrambashina.
I'm good. CJ, I'm fine. No question.
Yes, thank you.
Thank you, Honorable Chief Justice. I don't have any questions for Mr. Mrambashina. Thank you.
Thank you, Chief Justice. Mr. Mrambashina, I think the last time you appeared before us at the interview for the judges of the High Court, we raised this issue. And we explained that we are really constrained as long as those matters are pending before the Law Society. Our hands are tied. So until those issues are cleared, it's really difficult for us to consider you, if I may so speak. I don't know if you've got any comment to that or understand what we're saying.
I do not have any comments, and I understand fully what you are saying.
Thank you, Chief Justice. I have nothing else.
Thank you, Chief Justice. I have no questions.
Yes, thank you. We have come to the end of your interview. You are excused. Thank you. We will break for 30 minutes for lunch.